22 Brenda B. Marcos vs. Wilson G. Marcos. GR number 136490. October 19, 2000. Facts. RDC had ruled thus. Wherefore, the marriage between petitioner Brenda B. Marcos and respondent Wilson G. Marcos, solemnized on September 6, 1982 in Pasig City is declared null and void ab initio pursuant to Article 36 of the Family Code. Married twice. They first met sometime in 1980 when both of them were assigned at the Malacanang Palace, she as an escort of M.E. Marcos and he as a presidential guard of President Ferdinand Marcos. Through telephone conversations, they became acquainted and eventually became sweethearts. Due to his failure to engage in any gainful employment, they would often quarrel and as a consequence, he would hit and beat her. He would even force her to have sex with him despite her weariness. In 1992, they were already living separately. All the while, she was engrossed in the business of selling magic uling and chickens. On that day, when she saw him in their house, she was so angry that she lambasted him. He then turned violent, inflicting physical harm on her and even on her mother, who came to her aid. Injuries were diagnosed as contusions. August 1995, she together with her two sisters and driver, went to him at the Bliss unit in Mandaluyong to look for their missing child, Nico. He ran after them with a samurai and even beat her driver. The children described their father as cruel and physically abusive to them. The court quo found the appellant to be psychologically incapacitated to perform his marital obligations mainly because of his failure to find work to support his family and his violent attitude towards appellee and their children. CA held that psychological incapacity had not been established by the totality of the evidence presented. In the case before us, the appellant was not subjected to any psychological or psychiatric evaluation. The psychological findings about the appellant by psychiatrist Natividad Dayan were based only on the interviews conducted with the appellee. Issue: whether or not the Honorable Court of Appeals could set aside the findings by the Regional Trial Court of psychological incapacity simply because the respondent did not subject himself to psychological evaluation. Totality of evidence presented and the demeanor of all the witnesses should be the basis. Ruling: we agree with petitioner that the personal medical or psychological examination of respondent is not a requirement for a declaration of psychological incapacity. Nevertheless, the totality of the evidence she presented does not show such incapacity. Petitioner adds that the CA should have realized that under the circumstances, she had no choice but to rely on other sources of information in order to determine the psychological capacity of respondent, who had refused to submit himself to such tests. Although this court is sufficiently convinced that respondent failed to provide material support to the family and may have resorted to physical abuse and abandonment, the totality of his acts does not lead to a conclusion of psychological incapacity on his part. There is absolutely no showing that his defects were already present at the inception of the marriage or that they are incurable. His alleged psychological illness was traced only to said period and not to the inception of the marriage. No evidence showing that his condition is incurable, especially now that he is gainfully employed as a taxi driver. At best, the evidence presented by petitioner refers only to grounds for legal separation, not for declaring a marriage void.